As we began to discuss in Unit 5, when Brown overturned Plessy's separate but equal principle, that was only the beginning of the conversation about how the Equal Protection Clause should apply to historically unequal practices and institutions. Our first group of cases in this unit considers affirmative action and racial preferences in higher education. As with minority set-asides in public contracting, affirmative action and racial preference programs in higher education have sometimes been challenged by non-minority candidates. Regents of the University of California v. Bakke concerned a special admissions program at the University of California Davis Medical School. That program reserved 16 out of 100 seats in the incoming class for specific minority groups. Bakke, a white applicant who was not admitted to the medical school, challenged the program. Bakke's GPA and MCAT scores were higher than those of some of the applicants admitted under the special program. The California Supreme Court held that UC Davis's program violated equal protection, ordered Bakke to be admitted to the medical school, and further held that any race-based admissions program is unconstitutional. The U.S. Supreme Court agreed by an 8-1 majority that UC Davis's program was unconstitutional and that Bakke should be readmitted, but disagreed with the conclusion that race can never be a factor in admissions. There was no single majority opinion. Justice Powell wrote a plurality opinion announcing the judgment. One of UC Davis's arguments was that, as a white male, Bakke was not a member of a suspect class and that strict scrutiny therefore should not apply. Justice Powell noted that the characteristics discussed in Caroline Product's footnote 4 may be relevant in deciding whether or not to add new types of classifications to the list of suspect categories, but that racial and ethnic categories are subject to stringent examination without regard to these additional characteristics. Racial and ethnic distinctions of any sort, Justice Powell said, are inherently suspect and thus call for the most exacting judicial examination. According to Justice Powell, it is far too late to argue that the guarantee of equal protection to all persons permits the recognition of special wards entitled to a degree of protection greater than that accorded others. And in any event, the white majority itself is composed of various minority groups, most of which can lay claim to a history of prior discrimination. Justice Powell concluded that preferring members of any one group for no reason other than race or ethnic origin is discrimination for its own sake, and this the Constitution forbids. At the same time, Justice Powell stated, the goal of attaining a diverse student body is constitutionally permissible and also serves First Amendment interest. A state's interest in promoting a diverse student body in a public university is a compelling interest, Justice Powell suggested, but promoting diversity solely based on race is not necessary and might even prove counterproductive. Therefore, Justice Powell concluded, although an admissions program cannot be based solely on race, race or ethnic background may be deemed a plus in a particular applicant's file. Justice Brennan authored a partial concurrence joined by Justices White, Marshall, and Blackmun. According to Justice Brennan, racial classifications designed to serve remedial purposes should be subject to intermediate scrutiny, similar to gender discrimination, and UC Davis's program would satisfy intermediate scrutiny. In a separate partial concurrence, Justice Marshall argued that the purpose of the 14th Amendment was to remedy discrimination against blacks. He lamented that, now, when a state acts to remedy the effects of that legacy of discrimination, I cannot believe that the same Constitution stands as a barrier. In yet another separate partial concurrence, Justice Blackmun noted the many other preferences in university admissions beyond race. Justice Stevens, joined by Justices Berger, Stewart, and Rehnquist, argued that the case could have been decided solely on statutory grounds under Title VI of the Civil Rights Act of 1964. The court took up affirmative action again in university admissions in 2003 in Grutter v. Bollinger. Grutter involved a challenge to a University of Michigan law school admissions policy that sought to attract a critical mass of underrepresented minority students by giving substantial weight to racial and ethnic diversity. The court upheld this admissions program by a 5-4 majority. In her opinion for the majority, Justice O'Connor agreed that strict scrutiny should apply, but further endorsed Justice Powell's view that student body diversity is a compelling state interest that can justify the use of race in university admissions. Although the minority set-aside contracting cases suggest remedying past discrimination is the only compelling state interest, Justice O'Connor stated, this does not foreclose a compelling interest in a diverse student body in university admissions. Michigan's program, she said, bears the hallmarks of a narrowly tailored plan. What are such hallmarks? What is not allowed, Justice O'Connor said, are mere quotas or programs that insulate minorities from the competition of admission. In contrast, what is allowed is a program that considers race or ethnicity more flexibly as a plus factor in the context of individualized consideration of each and every applicant. Although race cannot be the defining feature of the application, narrow tailoring does not require exhaustion of every conceivable race-neutral alternative. At the same time, Justice O'Connor stated, race-conscious admissions policies must be limited in time. We expect, she said, that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. This latter point caught Justice Ginsburg's attention. In a concurrence joined by Justice Breyer, Justice Ginsburg stated, one may hope, but not firmly forecast, that over the next generation's span, progress toward non-discrimination and genuinely equal opportunity will make it safe to sunset affirmative action. The conservative justices dissented. Justice Scalia argued that the criteria adopted by the majority are fuzzy and will provoke further litigation. Tempting targets, he suggested, will be those universities that talk the talk of multiculturalism and racial diversity in the courts, but walk the walk of tribalism and racial segregation on their campuses, through minority-only student organizations, separate minority housing opportunities, separate minority student centers, even separate minority-only graduation ceremonies. In his dissenting opinion, Justice Thomas quoted Frederick Douglass, "What I ask for the Negro is not benevolence, not pity, not sympathy, but simply justice. All I ask is, give him a chance to stand on his own legs. Let him alone." The deference the majority showed to the law school was not really strict scrutiny, Justice Thomas suggested, but was really an aesthetic concern. He believed the university should be forced to choose between its aesthetic and its exclusionary admissions system. That system, he said, is not a true meritocracy anyway, but racial distinctions are forbidden by the 14th Amendment. Further, he argued, admission preferences harm students. These overmatched students, he said, take the bait only to find that they cannot succeed in the cauldron of competition. And such preferences, he said, engender resentment and divisions. In a further dissent, Justice Rehnquist suggested the university's admissions data show that the program was not about achieving a critical mass of diversity, but about a thinly veiled quota for black students. In the same term, the court decided Gratz v. Bollinger, which examined the University of Michigan's undergraduate admissions program. The overall admissions program involved a point system based on factors such as high school grades, standardized test scores, curriculum strength, leadership, alumni relationships, and the like. A total of 100 points were required for admission. Members of underrepresented racial or ethnic groups were automatically awarded 20 points. This time, Justice O'Connor decided against the university, giving the conservative bloc the majority. Chief Justice Rehnquist wrote the majority opinion. According to Justice Rehnquist, this program was not narrowly tailored and did not satisfy Grutter's requirement of individual consideration. In a dissent, Justice Souter argued that this program is closer to what Grutter approves than what Bakke condemns. In another dissent, Justice Ginsburg stated that, without plans that provide specific remedies for past discrimination, schools will resort to camouflage in order to achieve that goal. Grutter and Gratz, not surprisingly, did not end political and legal fights over affirmative action in Michigan or elsewhere. In 2006, after Grutter and Gratz, Michigan amended its state constitution through a referendum process. The referendum passed by a 58 to 42% margin. It covered race preferences in public education as well as in public employment and contracting as follows. 1. The University of Michigan, Michigan State University, Wayne State University, and any other public college or university, community college, or school district shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. 2. The state shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. In Schuette v. Coalition to Defend Affirmative Action, a case mentioned in the notes after Gratz in our text, the court rejected an equal protection challenge to this amendment to the Michigan Constitution by a 6-2 margin, with only Justices Ginsburg and Sotomayor dissenting from the judgment and Justice Kagan recusing. In a plurality opinion joined by Justices Roberts and Alito, Justice Kennedy explained that this case is not about how the debate about racial preferences should be resolved. It is about who may resolve it. There is no authority in the Constitution of the United States or in this court's precedents for the judiciary to set aside Michigan laws that commit this policy determination to the voters. Curiously, Justice Kennedy's plurality opinion does not cite Romer v. Evans, the 1996 case overturning on equal protection grounds an amendment to the Colorado Constitution that precluded the extension of protected status to LGBT persons in Colorado's civil rights laws, which Justice Kennedy also wrote the majority opinion. In a separate concurrence, Justice Scalia, joined by Justice Thomas, went even further. He questioned the entire political process rationale derived from Caroline Product's footnote 4 as an old saw derived from a dictum in a footnote. In her dissent, Justice Sotomayor responded that the Caroline Product's footnote 4 political process rationale is important precisely in cases like this one. According to Justice Sotomayor, under our Constitution, majority rule is not without limit, and the political process doctrine grounded in the 14th Amendment is a central check on majority rule. And Justice Sotomayor cited Romer v. Evans as an important precedent concerning state constitutional referendums. The different results in Grutter and Gratz, amplified by Justice Kennedy's plurality opinion in Schuette, which seemed to contradict his earlier approach in Romer, together with the stark differences between the Scalia-Thomas concurrence and the Ginsburg-Sotomayor dissent, demonstrate the ongoing doctrinal and philosophical tensions over racial preferences.